So I always say we wear different hats. You know, if I have a phone call from a debtor, an individual, I have my debtor hat on. A creditor could call me and I put my creditor hat on and talk to the creditor. And then I could, get a phone call from the regulator and they could have a question about the file. And then now I'm talking to the regulator. I don't know really what other professions you would see that much interaction with the various stakeholders, but that's one of the reasons the profession is so exciting and diverse.
This is Net Learnings, the podcast that keeps finance and banking professionals ahead of the curve. In each episode, we focus on career growth and practical advice while mixing in the occasional war story. Join us as we tap into the minds of leaders and experts at some of the world's most notable financial services firms and enterprises. Let's get started.
Hello and welcome to Net Learnings. I'm your host, Kyle Peterdy. My guest today is Jennifer McCracken, partner at BDO Debt Solutions. Jennifer is a licensed insolvency trustee and brings nearly 25 years of experience in financial services and credit restructuring. Jennifer, welcome to the show and thank you for joining us.
Thanks for having me.
I suspect a lot of folks will have heard of BDO, a pretty large professional services firm with a global footprint, but BDO Debt Solutions may be new to many of our listeners. So can you give us kind of the Coles notes on what this division does?
Absolutely. So we have a corporate and consumer division. We're located all across the country. We basically take on formal engagements to help individuals and businesses that are in financial difficulty. And we always offer free initial meetings. So we have a lot of touch points with Canadians and understand from all walks of life. I could be talking to a senior, to a business person, to somebody who's just finished winding down a business, a student, etc. So we're all across the country. We help individuals and businesses that are in financial difficulty work through solutions. And our team's interesting in the sense that as we'll get into in the podcast, we're a very regulated industry. So our team consists of partners, trustees, financial advisors, like analysts at the front end, but then also the back end, so specialized teams for taxes and claims adjudication and things like that. So very interesting work. And we used to be very paper driven. Now everything's online. So I guess nonetheless, there's lots of paper in the work that we do.
I'm sure. Yeah, and we'll talk about that. Honestly, I'm really excited about this conversation. As you know, the goal of the podcast is to be a resource for folks looking for mobility, either into or within financial services and finance roles. And I've never really talked to anyone with your unique credentials and your experience set. So perhaps a good jumping off point would be to tell us, what does a licensed insolvency practitioner or a licensed insolvency trustee actually do?
Well, we're licensed through the federal government, so we actually have a trustee's license to take on formal engagements through the Bankruptcy and Insolvency Act, through sort of creditor-driven processes like receiverships. We wear lots of hats, and so we are an interesting profession in the sense that on any engagement I'm on, I'm actually kind of technically working for the creditors, right? Particularly for bankruptcy scenarios. It's liquidation, we collect the money. The creditors are the beneficiaries of the work we do. They register their claims, we pay out the money that's available. But practically speaking, a lot of our interactions actually with the debtor company or with the individual. So it's this neat role where you're interacting with an individual that's in financial difficulty, doing the work to benefit their creditors, and then all within a landscape of having regard for the regulator. So the insolvency system, no different than in the US. We care about the integrity. We want to avoid bankruptcy abuse of creditors. All that realm is there in the sense that we have regard that there be integrity to the statute. We have to have regard for case law. So I always say we wear different hats. If I have a phone call from a debtor, an individual, I have my debtor hat on. A creditor could call me and I put my creditor hat on and talk to the creditor. And then I could, get a phone call from the regulator and they could have a question about the file. And now I'm talking to the regulator. I don't know really what other professions you would see that much interaction with the various stakeholders, but that's one of the reasons the profession is so exciting and diverse.
Yeah, you answered one of my questions, which was, who's your actual customer? And your customer is not so necessarily your end user, so to speak, right? Or the person you interact most with. But what does a successful outcome look like in your line of work?
Well, that's a fantastic question because it kind of goes back to the piece I talked to with integrity. So a successful outcome, if you have an individual in an insolvency filing, it's that they are, the statute, the premise is that there's an honest and unfortunate debtor. So they are entitled to the financial relief. As long as they have proper dealings, we recover money for their creditors. We see an outcome for them that they discharge or compromise their debt and they're debt free and they become a member of society again, that they can now go off and do other things and be released of the financial burden of their debts. But another successful outcome is recovering money for the creditors, right? So we want to recover what's available. We talk a lot in the industry about maximizing realization for the creditors. So that's also an outcome that we will always have regard to what's fair to the creditors, what money's there that we can realize on for the creditors. And then again, having regard to the regulatory piece. So if I am on an engagement and I think that there's something that could be investigated further, we have mechanisms to report to the regulator and seek their involvement. So a successful outcome typically is ensuring we're balancing the priorities from all those standpoints.
Really interesting insight. I'm wondering if you can maybe just take us back to the beginning of your career and walk us through how you ended up in this line of business, because it's not something that you hear a lot about in business schools.
I would agree with you. And we don't have campaigns like the way CPAs and accounting firms sort of and do online campus recruitment. But I can say in the insolvency world, we are a niche industry. And I'm licensed through the federal government as a trustee, but most of us obtain our designation through a professional association called CAIRP. So it's CAIRP. And we obtain something similar to a CPA designation, but we obtain a CIRP. So we're Chartered Insolvency Restructuring Professional. So it's its own program of study. We article no different than how accountants article, right? We work at a firm, do the coursework, and sit for exams. I personally kind of fell into this. I was in the middle of finishing off my BA in psychology. So I always knew I would study psychology. I was obsessed with psychology at a very young age. So I was very much enjoying my degree and didn't know what my future was holding, but I certainly was loving what I was doing at school. And I just kind of fell into a summer job and expanded to the weekends. And then as soon as I graduated, like within a month, I had got signed on full-time at the firm, registered for the trustee program. And so after a little while working in it, I kind of knew that, okay, well, I'm going to give this a go. I think it's a really interesting profession, interesting field. And so I guess I kind of fell into it, but it was one that it basically, as soon as I kind of cut my teeth a little bit on it, I realized it was going to be fulfilling, challenging, rewarding, all the things you want in a career.
Yeah, no, I'm sure it's very challenging, and we'll talk more about that as we go. But I guess that sounds like maybe a bit of an atypical path. What would most folks like your peers and your counterparts, like how do they typically find their way in? Or is it maybe not that atypical?
Historically, Kyle, I would say most would come through an accounting background. So they were in audit at a CPA firm, and the restructuring team over here, which they're normally the funnest, most dynamic people at all the accountants listening can snicker, but they get a secondment to the restructuring team. And they also, they realize how dynamic and interesting the work is, and they stick with it. So once they finish their CPA, they then enroll in the trustee program. That would be typical, although I'll say now, like most professions, we're seeing people from different backgrounds now. So I was licensed in 2009. So it was a few years ago where generally when I was getting licensed, most people came from that background now. And I sit for board exams now. I see students with all different backgrounds. They, have science backgrounds, no degree. Some people just actually come in and professionally learn the work hands-on. And I am a huge proponent of diversity and thought diversity in the workplace, diversity in background. So I am excited at the fact that we have people from different backgrounds now, kind of more in the profession than historically it was really more of an accounting-based background.
You mentioned you're in Canada, but I'm curious, just because we have international listeners and folks all over, what would be sort of the equivalent of your role title or your designation maybe in like the United States? Is there an exact proxy or an approximate equivalent?
I guess the quick answer is no. And the reason I say that is that bankruptcy legislation, bankruptcy law in the United States is a lawyer-driven process, and it's heavily court mandated, which actually I think is fascinating. If you want to sort of search bankruptcy offenses in the United States, you can read some fascinating case law. The legislation to me is really, really interesting. So there isn't really a similar type role, although I guess you could say that me as a licensed insolvency trustee, I am the equivalent of the bankruptcy lawyer in the United States. One distinction would be, though, that under our mandates in the Bankruptcy and Insolvency Act, it's really mostly trustee-driven. There are times we actually are required to go into court. Some of our more formal restructuring proceedings are more heavily court-driven, but It's really more, we're really administering the statute without having to go to court for every little aspect of the administration. In the United States, it's different. Every single juncture, there is some court involvement. So there is that distinction. There also are distinctions around, in the United States, there's means tests. So when an individual is declared bankrupt, there's a test that's employed to sort of assess which chapter they proceed through. In Canada, we don't have necessarily that similarity. But I think one other aspect, though, I will say too, is that our statutes also do provide for cross-border. So I think very interesting cases to read about are the ones that have this cross-border piece where there's a U.S. entity and a Canadian entity and there's more formal restructuring. So there are times where the statutes kind of come together in those types of engagements.
Yeah, that must be totally fascinating. Just to kind of stress for our listeners how sort of niche the field is that Jennifer's in, the CAIRP, the organization that you're a member of, I think has about 1,400 members, and CPA Canada has like almost 220,000. So that's quite a small subset. I find that really, really interesting.
It is, and to me, the work in a way it is similar in the sense that, if you're a CPA, you have regard for your professional conduct, professional rules. You're also in a very regulated profession. If you're providing advice to a business around their tax filings or conducting an audit, you are following GAAP. You're alive to all the risks for your client, and you want to correct any errors or any omissions, or you want the company to be clean and in a good standing. You want the best for your client. So the work is similar, but I guess to a certain extent, I guess you could maybe kind of point the finger that maybe we haven't done a good enough job advertising the work that we do in recruitment in the industry. So maybe there's more to come to bring awareness to expand our membership.
Maybe this podcast will help.
Hey, I'm hoping.
All right. Something I'm also curious about, how much crossover is there between personal restructuring work and corporate? And I ask, I guess, what I'm trying to tease out is what percentage of personal insolvencies are actually the result of like a business venture going sideways and enforcement action, being taken against the company.
Yeah, I mean, for me, I would say at least 30% of my practice. And when I say that, I mean individuals that operated corporations. So yes, you're right. There could be directors' liabilities. There could be personal guarantees. The company is in of itself its own person. So you provide advice around the business and then what's the ripple down effect to you as the director of the company, but also owner-operated businesses. You'd be surprised how many insolvency filings and workarounds I do for individuals that operated as sole proprietorship. So they didn't incorporate, they didn't have an LTD, and I've seen it on really large scales, like shockingly, we talk about like the top line revenue. It's remarkable that somebody would not have incorporated the company. So absolutely, there is a business component to a lot of what we do, more so than I think people realize. So I could say sort of in circles, if I'm at a networking event or I'm out and someone says, oh, you do consumer work, I think there might be a stereotype that I'm just helping families and students and that we don't really touch or look at business, but I very much encourage individuals that are actually articling and working towards being a trustee that they do get corporate experience, because even as a consumer practitioner, you need it. You need to read financial statements. You need to understand the workarounds for the business. Like you have to have that knowledge to advise the individual that's an owner operator or who ran a corporation.
What surprised you most about this line of work when you first started?
The diversity of the files. So like with any course of study, everything seems so black and white, right? You read a legislation, you read a rule and say, okay, well, this is exactly, and there's a rigidity around, like a newly licensed trustee is somebody that generally is known to be quite rigid because they've just come out of their program of study and they think everything's black and white. You get more flexibility once you're licensed. You get more space at the firm you're working at to kind of be more involved on the front end of the mandate. So early on in my career, I was at a boutique firm and we did amazing file work. I still look back and marvel at just the very interesting engagements that we took on, the complexity. And that was where I learned the gray areas that you may think something is so clear, so black and white, but you don't know that there's a case or decision lurking, maybe it was 10 years old, 5 years old, that's relevant to this scenario that impacts your perception on what you should do as a practitioner, whether it's a realization of asset or abandonment of an asset. So the intertwinement of the legal aspects and the accounting aspects, and then just whether it's common law or statute based, all of these things factor in our decision making on files. And that I earlier on in my career, I don't think I had as much of a realization. It wasn't until I was at a firm that had really interesting, very complex work that really kind of pushed the envelope in terms of my thinking around, is this issue black and white? And I think that it very much governs the way I operate now. And I'm most grateful I had that. And I had also some really bad setbacks as well in terms of like bad outcomes on files. And that we can talk about this more, but I'm a huge believer that the mistakes you make and the setbacks you have are really where you grow the most.
Right. Yeah, that's tremendous advice. Okay, I think we should actually maybe pause here for something of an aside, because we've used some pretty technical terms, and I think it'd be worth clearing up kind of questions or confusion around what some of those terms or definitions actually mean. So just a friendly reminder, you're in Canada. So if we get too nuanced on sort of legalese and legal definitions, they won't expand across jurisdictions. And maybe we can talk about, in some instances, if there's like a US equivalent or somewhere else in the Commonwealth, just to be helpful. But I think about sort of financial distress as a spectrum. So I think probably directionally, a lot of these words are going to work anyways. And so I made a list, and I'll read the whole list if you don't mind. And from there, we'll come back and kind of do one by one. But the words I'm curious about are insolvency, receivership, consumer proposal, bankruptcy, which you've used. And then maybe within that, I know you mentioned in the US, they have like different chapters. Like, are there different types of bankruptcy? What is bankruptcy protection? And what is restructuring? That's the list of sort of 6 words. If there are any others that you think are important, you can certainly add them. And then the only other piece here is, I would say, are they the same for a business as they are for a person? So that's a lot. We can go through them one by one, but that's kind of my ask. So the first one is insolvency.
Okay, so this is the same for a business or person. So insolvency is the same for a corporation or for an individual. So you think about it this way, an individual who can't pay their debts as they become due, they have cash flow constraints. So a creditor is knocking on the door, they don't have the money. The other way is through asset values. So there might be a lack of liquidity to the values, or the values could have depreciated. So if you look at a balance sheet and take asset values versus liabilities, when we see the scales tipping in the wrong direction, that's insolvency. So insolvency is not a legal state, but it is normally always a precursor to some type of legal state like bankruptcy and receivership. So it is an indicator of financial difficulty, cash flow constraints, asset issues, and any corporation or individual that knows that they're insolvent, that they're in financial distress, typically that's when they reach out to a trustee for advice.
Got it. So if we look at that financial distress spectrum, this is sort of at the early end of it. Insolvency kind of is a precursor to other things.
Absolutely.
Okay. That's helpful. Then what is receivership?
So that's a non-bankrupt state, but it is a legal state. So it's usually when a creditor, a secured creditor, has initiated some type of seizure and they're seizing and selling an asset for the benefit of a creditor. So I have acted as receiver on file. So you can be appointed by court order, or you can have a private appointment. And really your mandate is to go in, seize the asset, sell it, and pay it for the benefit of the creditors. And as part of your mandate, you will also have sightline to other liabilities, other creditors. There might be a recommendation for a bankruptcy, depending on what you find when you go in. But it's a non-bankrupt asset seizure.
But a legal state.
But a legal state, yes.
And so when a lender takes enforcement action, they would hire or appoint a receiver through that was what you called a private appointment?
Mm-hmm.
Okay.
That's right. And then there's also sections of the Bankruptcy Act that mandate notices for receivers when we're appointed. So typically there will be the involvement of a lawyer for the secured creditor. They find a trustee to act as receiver, and they'll work kind of directly with the company on the appointment. And the company typically at that stage also has its own legal counsel. So it sounds like really simple, like all of a sudden one day a bailiff shows up with the trustee and has changed the locks. But usually there's a lot of a lead up time before the receivership actually happens.
When even then there may have been a quarter or many months at least of like tripped covenants or something for that individual's business that they own or what have you, right? I mean, it doesn't just happen overnight.
Oh, absolutely. There's default notice. And a lot of times there's an entertainment of forbearance agreements, right? So the lender might want to, again, counsel for the lender might want to put to the debtor company, here's some forbearance terms to get some commitments from the business of how they're going to rectify. So we're very alive to, in the receivership world, we call it improvident realization. So you really only want to get that receiver in when other options have been exhausted. And a lender doesn't want to come across as being heavy-handed to a business, but as I say, there is that lead up where ultimately sometimes the receivership is really what needs to happen because the lender needs closure at that point. They're not moving anywhere. There also could be a risk that the asset value is going down. All these things are considered before an appointment.
Okay. Consumer proposal. I don't know if this is a uniquely Canadian term. I think it's a uniquely consumer term, but what is a consumer proposal?
My understanding is in the States, Chapter 13 is the equivalent. So that's that means test I was referencing. So there is some type of equivalent where there's a proposal to creditors. So in Canada, though, the definition of consumer proposal is uniquely Canadian. I agree with you on that. And so it is an alternative to bankruptcy. It is also, though you are in a legal state, you're considered a consumer debtor. So you're not a bankrupt, but you are called a consumer debtor. And you've put forward an arrangement or proposal to your creditors. So in bankruptcy, when debts are written off, we call it discharging debt. In proposals, we call it compromise. So the creditors vote on the proposed arrangement. It goes through a court approval process. So it becomes basically a court-sanctioned agreement with creditors. And one unique thing with a consumer proposal that separates it from bankruptcy is that individuals are what we call a debtor in possession. So they retain title to their assets. There's a disclosure of assets, but there's no liquidation type scenario going on with their assets, which makes it a distinction from bankruptcy.
So it's something about like a temporary state, like of negotiations almost?
Yes, so the creditor's rights are stayed, and we'll get to that too with the bankruptcy protection. So a lot of, bankruptcy creates a stay of proceedings where creditors' rights are, the trustee steps in, stays any actions, assets are now in the custody of the trustee for the benefit of the creditors. In the restructuring and proposal scenarios, yes, there's the creditor protection that the creditors the debtor company can't be fighting lawsuits while it's trying to make proposals to its creditors. There is creditor protection, but the assets don't necessarily, that they're not vesting with the trustee to be sold. The company needs the creditor protection to get financial relief, but the intent is that the company and the individual will work itself around that. They'll find an arrangement to offer the best that they can to their creditors and compromise the debt and move on. So it's really meant to be bankruptcy. You could think of being terminal or end. Proposal or restructuring is really a workaround that there isn't necessarily an end to the business. It's really turning over that new leaf.
So this may be a silly question. Would you be the one or someone in your shoes be the one that helps them negotiate that proposal?
Absolutely. So again, this is where it's the dual hats, right? So I might, this is where a lot of times we talk about insolvency, having difficult conversations. So I might meet with somebody who discloses something to me that is impactful to their proposal. It could be a transaction that they need to report on that I need to comment on and do an analysis. So at the end of the day, we do make a recommendation that we think is fair to the creditors. And if creditors want us to obtain bank statements and investigate transactions, if there's a need to do an examination, we'll make those referrals. So we're talking a lot to the debtor company or to the individual, but at the end of the day, we have regard for the integrity of the statute, and we will do those negotiations with the creditors. We chair meetings of creditors, obtain their votes, and once we have the requisite majority, the proposal itself gets accepted, it's passed, it's court sanctioned. We collect the proposal money and we distribute it. So we are really the facilitator in that scenario. And the creditors have comfort that we're really kind of like the eyes and ears of the court. Right. So I'm not a debtor's advocate where we're shielding things and we're kind of massaging the situation, where we are reporting impartially on the situation. And so that really maintains the integrity of the workaround.
Okay, so item 4 on the list is then bankruptcy. What is bankruptcy? So
bankruptcy is a legal state, and the best way to say it, it's the liquidation type scenario where the trustee steps in, collects as much as we can for income, as much as we can for assets, and we report on the discharge. And so corporations don't typically obtain a discharge. There is a provision in the Bankruptcy Act, actually, and I had it on one file I was saying that boutique firm I worked at where a corporation actually did satisfy its debts in full in bankruptcy, and it was a bit of a head scratcher how to get the corporation discharged. But generally speaking, the discharge is really relevant to individuals. They go through the process, obtain the discharge, get their fresh start. Corporations, it really is just the end, the wind down of the business, relies on the assets and pay it out to the appropriate parties.
So a bit of an aside where outside the definitions here, I'm just curious, and you may or may not be able to give a reasonable answer, but like what percentage of total debt outstanding is typically written off in a discharge scenario? Like if I owed, $100,000, would they let me walk with 30 or 70? Like what does that look like?
It varies because the statutorily an individual only has to pay based on income and based on asset values. And this is similar to the U.S. So the U.S. has state exemptions, and they also have exemptions around income. We have something similar in Canada. So if creditors have the right to participate, once someone has paid the minimum required amounts, and that's, when I say the minimum, I mean that's the amount creditors are entitled to. If they're wanting more money, they do have the right to participate, the right to weigh in at the discharge. So it varies. I have bankruptcy files where there's a return of, like 30% to the creditors. I've had bankruptcy files where situations change and you get almost a full recovery on the debt. There's no hard and fast rule around it. There's a range of 0, honestly, up to 100.
Yeah, it was a bit of an unfair question, but that's crazy to think that it can go from 0 to all.
Yeah, it can. And think about it this way. Again, another distinction between the American and Canadian statutes. In Canada, any assets that devolve or become due. So I have had people who have inheritances during their bankruptcy, and that asset is technically up for grabs. So you can have some unforeseen assets that come into the hands of the individual while they're in bankruptcy. And that's what changes the recovery. In the States, though, once someone's filed, their post-filing assets are theirs. And so again, it's just some of the nuances between the two statutes.
Okay, that's super helpful. And then, so is it worth covering bankruptcy protection and restructuring?
Yeah, I mean, in a way, I kind of see them as the same thing. So bankruptcy protection is, the way I would view it is that it's for a corporation or individual who's protecting themselves from bankruptcy. So it is that workaround through proposals. I haven't gone into too much detail, but large restructuring engagements like Air Canada, like huge corporations go through something called the CCAA, the Company Creditors Arrangement Act. And those types of statutes, we would call those bankruptcy protection because the corporation obtains the stay and they're avoiding bankruptcy. They're working through a compromise and workaround, and it is a form of a restructuring engagement. My only other comment on the difference between the United States and Canada is that my understanding of the U.S. statutes is that the blanket sort of umbrella term is everything's bankruptcy. There's various chapters, but it's all within the bankruptcy court. And here in Canada, it's a little bit different. We really do make the distinction that like a corporation restructuring under CCAA, we would never call it a bankrupt. But in the United States, my understanding is all of that is within the umbrella term of bankruptcy.
Interesting and very nuanced. Were there any words that I missed? Are there any other words you think people ought to know?
No, you've pretty much covered it. I'm pretty impressed, yeah. And you're going to have to get a license one day.
Yeah, maybe. Who knows? It sounds very interesting. I got to be honest. It sounds very, very interesting. So you kind of alluded to this earlier, but maybe you want to highlight a couple like myths or misconceptions that are out there about working with individuals or businesses that are in financial distress.
Oh, yeah, there's so many. I would say, and one that's near and dear to my heart is that I'll start the discussion by saying there's a scale, right? So you have misfortune to mismanagement, and somehow the financial difficulty, it could be both ends, but it's somehow caught on that scale. And what a lot of people think about businesses, individuals that are in financial difficulties, that they were irresponsible, they ran the business roughshod, they really didn't care about their creditors, they were irresponsible.
Or fraud.
A lot of individuals come into this with a really heavy heart. They're very ashamed. They don't want to be meeting with a licensed insolvency trustee. They found themselves in difficult circumstances through the economy, through COVID. Let's take COVID, for example, right? Like how many businesses suffered because of this? So that is a misconception that every single person that accesses the insolvency system is uneducated, irresponsible, abuse their creditors. It really isn't the case. There might be an element of that, yes. Like in any profession, there might be someone who's defrauded their creditors. I'm not saying it doesn't happen, but by and large, the people we meet, they are there because they've tried every other avenue, and their last resort now is some type of restructuring engagement.
What do you most like about this line of work? And maybe just to balance it out, what do you sort of least enjoy?
What I most like is the communication. So I literally spend most of my day talking on the phone. So whether it's internal discussions, external discussions, and there's a huge education piece to what we do. So whether I'm mentoring a student, whether I'm talking to a debtor who's wanting advice about, what their options are, like you're always educating individuals. There's a huge financial literacy piece, and I'm really passionate about that. And we can talk more about my social media channels, but it's really important to me. While I'm here on this earth, I want to impart the knowledge and wisdom that I have within this field and the education of clients, of debtors, of creditors, of any Canadian or American. I really love that opportunity. The part that gets to be a little grating, and maybe this just speaks to how long I've been in the industry, it's the myth buster type question. So I'll give you a few zingers. So the common questions of what, bankruptcy is not free? My friend filed bankruptcy. He only had to pay X amount of money. Or, oh, I thought my bankruptcy would be this many months. I read this online. Or what's wrong with my credit report? Why is there this error on my credit? So those common kind of myth buster type questions, when you get those regularly on a weekly, daily basis, that's why financial literacy is such a passion, because I know I can see the gaps. Right. And we answer the same questions over and over. So there's something to be said that there's an opportunity to educate individuals.
Well, I mean, your average consumer can't even draw up like a family budget, let alone understand, the once in a lifetime, hopefully never bankruptcy process or insolvency process. So that is interesting that you call that out, because I'm sure there's a huge gap in the market in terms of like what people know and think they know.
Yeah, and a lot of the advice sort of, oh, I was in a bar and this guy wrote it on a napkin and that kind of stuff where and actually I will say that when I started out in insolvency, there wasn't really the internet. We advertised like on SkyTrains and in the Yellow Pages. And I think we were like using Ask Jeeves, when we wanted to Google something. So definitely a totally different era now. And so historically when I met with people, the information was very new, very fresh. They'd really, oh, wow, it was really hard to find information unless you went to the superintendent of bankruptcy's office and got a pamphlet. There really wasn't a lot of information about bankruptcy to the public. It's different now, right? There's blogs. You can follow people on TikTok, Instagram. You can go to firm websites. And so there is a lot of information out there, but I do have to say you have to be cautious about what you're reading, so that at the end of the day, you do have to still go to that licensed insolvency trustee to get the real thing.
Makes sense. I'm going to ask another question that may or may not be totally fair, because I'm sure it varies, but like, you mentioned you're on the phone a lot. What does kind of a typical day or maybe a week look like? And is there any sort of seasonality in your business? Like, do you get a big influx after tax season? What does that look like?
No, you would think that, right? A lot of people think after tax season we get an influx. And the one reason I'll tell you why is that a lot of people have tax problems, aren't adhering to tax deadlines. So that's why.
That's fair.
But the other one too is holidays, right? After Hanukkah, Christmas, oh, there was a big spend come January when those credit card statements come in. No. Absolutely not. So no, there isn't seasonality. I would say though that we are, if you look at insolvency trends, like through the superintendent of bankruptcy, they publish numbers on filings. We can see filings have been going up in the last 12 months. So a lot of it actually, if you were to predict trends, it would be tied more to the economy, to inflation, to Bank of Canada interest rates. If you want to prognosticate on numbers, you would look more to the economy and make predictions based on that, as opposed to something as like simple like credit card statements or tax season. But yeah, typical day, I'm keeping in mind I'm a partner. So we've got the partner piece. I have the local partnership here in Vancouver that I have a lot of interaction with the partners around here. But there's mentoring, lots of phone calls, a ton of emails, signing off on documents, reports, banking. I do an element of court. So I've been speaking in court for over 20 years. And so it's preparing for court applications, speaking in court. It kind of runs the gamut. Every day is different, I will say, and the day flies by. So if anybody wants sort of a fast-paced career, this is one. And where I am in Vancouver now, I have a lot of people who always say to me, because I'm in an internal office, so people walk by all the time, they'll always say to me, you're so busy. You're always, you're always on the phone. You're always on a call. Or they'll stop me and go, what is it that you do here? Because so there's a sense of, when you do this work, you stand out to the person sort of plugging away on tax returns at T1 season, or someone sort of plugging away on an audit file. It's a different pace to what we do for sure.
Can you share maybe an example of like a key project or accomplishment that really accelerated your career?
I would say public speaking. And so I'm a huge fan of people putting themselves out there, even if they're unsure of themselves. I think public speaking's right up there with heights in terms of fears. So it's not for everybody, but it is a skill that you will need at some point in your career. So if you plan to be a leader, you plan to lead a project, you are going to be standing in front of people, guiding them, responding to things on the fly. And so I can tell you, just give you a little bit of a story. The first time I spoke we're a tight-knit community, as you've commented on. So I got asked during my mat leave, and I'd just been licensed to do a presentation at a local conference. And I was used to seeing sort of the more senior gray hairs presenting, really looked up to them. And so I knew that I was going to go in, not having, like I was already having a break on my mat leave, I was going to show up and present to this very sort of senior, seasoned group of people. And I had to do something like hot topics and build out the content myself. And so I didn't have a comfort level initially, but I just said to myself, I had like an inner voice that said, do it, and you need to do this, and this is how you're going to build your own personal brand. And I didn't stop after that. I speak at those industry events, I speak at academic conferences. So what happens with that is you build confidence, you build out your network, people get a sense of your brand, who you are. It's an opportunity to showcase your personality. A lot of what we do, I'm interacting, if I want files, I want a lawyer to send me a file, or I have a banker that I want to work with. You need to be able to sell yourself and interact with people and have those discussions. I think public speaking and presentations are a really great way to learn that skill and do it in a way that you're really challenging yourself, right? It's a very intimidating thing. You can really pat yourself on the back after you've done something like that. And the last bit I'll say is that when I look back on those experiences and how I really had to push myself, I didn't have a lot of mentorship in that regard. I had to really just do it, sort of jump in. Where the benefits are now is that I never anticipated that I would do radio interviews, TV interviews, and now these are things that happen on a very regular basis in my business, and it's ones that my firm finds for me to do, and there's some that media outlets reach out to me and ask me. And if I hadn't really pushed public speaking, if I hadn't pushed doing those presentations, I wouldn't be able to do that as well. So you never know where those skills are going to translate later on in your career. So I'm a huge believer in putting yourself out there and doing presentations and speaking.
Love that. So you've given us so much insight, and I think it'd be important just to sort of reinforce some of the key takeaways. So what, if you could say, are kind of 2 or 3 of the most important skills that someone should have if they want to get into and be successful in this line of work?
Well, definitely communication. So oral communication, oratory skills is key because you are communicating with the courts, you're communicating with the regulator, you're chairing meetings of creditors, reading reports, doing analysis. I speak in court regularly. Again, going back to those hats, I'm interacting in a work day with, depending on the file, the engagements I have on my desk with lawyers that referred the work, with the creditors, with the debtor, with counsel. I could have the superintendent's office phone and have a query. So that being able to communicate effectively, professionally is really, really important. I would also say having professional judgment. So kind of going back to what I said earlier, that we might think there's one way of doing things or one way of administering things, but you have to be able to exercise professional judgment. It starts in the beginning of client acceptance. Am I a right fit for this file? Do we have the expertise? And it goes all the way through administering the engagement. One thing to keep in mind is that for insolvency mandates, we can't do, in the legal world, they call it tools down. Once we are on an engagement, we are the trustee of record until we're substituted by court order. So professional judgment when you bring work in, and professional judgment on what it will take to administer the file and have the ideal result for the stakeholders is really, really key. And I would also just say sort of strategic thinking. So strategic thinking around outcomes. You want to understand case law, be up to date. You have to stay connected in your industry. Marketing and business development is huge. You have to keep up professional development. So you really do. You can't sit back on, if I just sat back and relied on my insolvency knowledge when I got my license nearly 15 years ago, I'm going to be left in the dust, right? Innovation is key, moving with the time, staying current. All of these things make for a strong practitioner.
It sounds like a very, very dynamic environment. So Jennifer, where can people go to connect with you or learn more about what you do? I know you have some social channels and things.
I do. So I'm really passionate about personal finance, budgeting, cooking on a budget. A lot of it's kind of family focused, and it's really bare bones basic around budgeting, cash savings, etc. So my 2 channels it's on Instagram and on TikTok. It's Fast Finance with Jennifer. I also love posting on LinkedIn, writing sort of more blog style format. So I report on consumer matters, consumer finance, economic updates, like all that kind of stuff. It's a little bit of a different feel, a little bit more formal on LinkedIn, but nonetheless, I do want to have followers there as well. So I really believe in brand, in your personal brand, and promoting, for me, it's promoting financial literacy and financial awareness.
That's great advice. And we'll actually leave those links in the show notes for any of our listeners that want to be able to go there and check it out. And I encourage you to do that. So we're coming up on time. I just want to ask sort of one final question, and that's if you weren't a licensed insolvency trustee, what would you be doing?
That's hard because I I mean, I've stayed in this profession for a long time, but I really am more the type that I would have bounced around just because of the way my mind works. I like a challenge. But I will say that I have a huge passion for forensic psychology. So when I graduated, I was working in the forensics lab, and forensic psychology is psychology in the criminal justice system. So it can be through prisons and institutions. It could be through victim services. It could be through psychological profiling, policing, etc. So I probably would have explored some type of master's or PhD in psychology in that realm.
Very interesting. I hear all kinds of cool answers to that. I'd be fishing, or I'd be in the military, or that would be a forensic psychologist is definitely unique. So Jennifer, this has been terrific. I honestly, I can't thank you enough. This has been very, very insightful. So on behalf of our listeners, thank you, and let's keep in touch.
Thank you.
Thanks for listening to this episode of Net Learnings. This podcast is powered by CFI, an organization on a mission to enhance the skills, knowledge, and productivity of finance and banking professionals. If you enjoyed what you heard in this episode, make sure to follow Net Learnings wherever you listen to your favorite podcasts, or visit us online at corporatefinanceinstitute.com/podcast. See you next time.